Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Seeson. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Seeson.
Hi, everybody. Welcome to the new episode of the Third Fridays podcast. We are in the month of May. The year is almost halfway over, which is insane. But we're here to talk to you guys today about a very important case that was issued a while ago. But we have some updates based on how we're applying that on the front lines. So what we're going to do is talk about how that case really not necessarily changed the game, but provided a little bit more emphasis on some of the tactics that we employ and see what results are emanating from it to provide you guys with some takeaways going forward. So to help me out here, I have two of my very stellar and talented attorney coworkers and colleagues at the firm. Welcome back to the podcast, Lehr, and for the first time on the Third Fridays podcast, Brian Mooney. Welcome, guys.
Thank you.
Thanks for having me on.
Good to be back.
Yeah, so this case, I think that most practitioners, attorney-wise, probably know about it right now. Like, you can say it and they know what it means. And this opinion from the Court of Appeals in Lasley, right, did send some shockwaves throughout the industry, mostly I think because it was the Court of Appeals that had a chance to review it.
Right.
But maybe in your own words, what was Lasley, and what did the court decide in that case?
So you said earlier that it created waves, and while it did create waves, the waves were, I think, unfounded, honestly, because Lasley really just puts into effect what was. So what we have in comp is we have a statute that we typically rely on. We always do under 300C10, which essentially allows the carrier to request depositions or cross-examine any provider whose reports are in the e-case file. We've had some issues in the past with judges denying that, even though the statute itself doesn't provide for any discretionary aspect, it's not up to the deference of the judge. It's a mandatory provision. I mean, it uses the word shall as opposed to may. Basically, the referee, the judge here, has to adjourn a case if depositions of a provider are requested. And we've gotten pushback in the past, but what Lasley does essentially is putting that into effect. And like you pointed out, Christian, it was the Court of Appeals that decided, the highest court in New York, that essentially applied that statute to a case. And we've been using that ever since. I think Lasley came out maybe 6 months or so ago. And like you said, I mean, everyone seems to know about it. Counsel knows about it. Judges know about it. Whether they apply it correctly is another question. But the name Lasley versus Wegman is something that, we see commonly at this point, I think.
Yeah, like I think that when it was issued, right, people are talking about this very constant barrage almost of like, oh, this is new. Like, we can do all these things. And it's almost really just elevating really what was already there.
Exactly.
Right? So, like in Lasley, you had a situation where the claimant had a continuing award at total disability, but that resulted, or was going to result, presumably, in a very, very large scale protracted healing period award for the employer and carrier. So it actually made sense to timely cross-examine or timely request to cross-examine the treating doctors, because you want to avoid protracted healing period, right? A lot of judges in schedule cases will say, oh, it's a schedule, you get to take credit for it. But a lot of, what we do, especially in defiance of tentative rates, is really going to attack protracted healing period in that service, right? If you keep a tentative rate in place, then anytime an adversary wants to add PHP, they can relitigate that issue, right? And potentially get a total. And then we know that the friendly advocacy of the board, if they know what the claimant is doing and what they're asking for, they're probably more likely to grant it, right? So you almost have to take what we have and be proactive about that. Now, Brian, you're also, you've made these requests before Lasley came out. Was that your experience too, that, when we would try to do these things, you'd get the same pushback from judges and claimants counsel?
Yeah, I mean, Tomer said, this case law weirdly sent shockwaves because the law already existed, but, we're here talking about it now. So it's only imagined before Lasley,
right,
how abusive maybe the judges were, or even claimants counsel. Hey, like, there's an IME that concedes, or this is a non-issue, and things get brushed under the rug, So this case, gives us a little more teeth in our briefs, in our summations. But you still see it today, law judges will find an excuse not to give you the opportunity to depose the doctor. If there's not a conflict in medical opinion. So it comes up a lot, and today I have one that's out on appeal, and we'll see what happens.
Yeah. I was actually just going to comment on that too, because something that we constantly see from judges is the reluctance to direct depositions or develop the issue because there isn't contradicting medicals, and that was the issue that was actually before the court in Lasley, where the carrier didn't have any contradicting medicals, so the claimant was able to ride high on his total disability opinions, and that was the basis for why it was appealed and ultimately reversed. I mean, that's why we're getting this even still. So, what Lasley also helps push is that we don't need to have a contradicting medical opinion to request depositions. The rule is pretty straightforward and simple. It's if there is a provider in the board's file and depositions are requested of that provider, adjourn.
Right.
We'll stop.
Right. You're not making a decision on what's before you if there's a timely request to cross-examine the expert whose reports are being used to advance the argument from the other side, right?
Mm-hmm.
I remember even just like going back to when I first started doing this, like judges were like, oh, that's the way it's done, right? Like you have to get an IME to refute the claimant's disability. And even though that's the most common way to do it, I had to really start looking at the law to realize that the judges were wrong, right? That the judges were not really serving that purpose, because you need an advocate to actually supplant that. The advocate's role is to present the argument so that, our clients are served properly and don't have to deal with, either a judge who, wants to advance a case in his or her own way, or a judge who's an advocate for the claimant, or a claimant's attorney who, pre-Lasley maybe doesn't even know what 300.10c is, right? Like most claimants' attorneys, when they come in there, they're like, oh, well, we got this report. Like we're going to get you awards based on the 100% rating from your doctor that, we send you to every single time.
Yeah, I feel some law judges and claimants counsel also, it seems like litigation sometimes is something nobody wants to do.
Right.
Or like they forget that we're lawyers.
Yeah.
So it's like asking to request to develop the record and have a deposition is like a bad thing.
Yeah.
Or like, aren't we all lawyers here? You're a judge. Like, shouldn't we litigate an issue that's in dispute?
I can almost understand it from the claimant's attorney's perspective, right? Like, for instance, a lot of the work being put in by the claimant's attorney, if they believe they can get a very similar result without putting in the same type of work, then it just becomes like a math problem in terms of like time spent versus like fees received, right?
Mhm.
When it's like statutorily in place to get this percentage on this type of award, you know, I kind of get it from the claimant. I think they're actually being creative when they want to avoid litigation, right? But it's become so commonplace now that whenever you do want to litigate, like the claim starter is like, whoa,
Yeah.
what?
Yeah.
So they do feel that, right? Like, oh, we're not lawyers. We're here.
Right.
Yeah.
We're here.
It's almost bizarre too, because it becomes abusive, honestly, at some point when the claimant continues to get total disability findings months on end for sometimes a benign minor, illness or condition, and to not cross-examine a doctor who's continuing to find that total disability finding is kind of bonkers to me. I mean, if you're saying that the claimant can't do anything at all for 3 months post-injury, that it doesn't need another medical opinion to contradict that. That just defies logic, really.
Right. It strikes against like the common sense that really an administrative area of law is designed to be, right?
You would think, right?
Sometimes in summation arguments, we're saying, maybe the opening line is, Judge, we're 10 months post-surgery, by the way, right? Like before you get into the credibility of the doctors, Judge, just so you know, we're 10 months post-surgery, right? Because you can't always just say like he said this and she said that. Like when you inject a little bit of like the flavor, it's just like, okay, like now we're like cooking with something here that like is a little bit different than your run of the mill. Oh, total versus 50%.
Right.
Like, what do I do? I'll just split it and find a 75. Like,
Yeah, it's crazy how far some common sense will go.
yeah. So, okay, so now the landscape, right, is a little bit different because you guys are saying that, we have this thing that helps the brief. We have this thing that practitioners know about, right? So as we start to implement them in our files, right, in our cases, I know you guys each have a case that you wanted to talk about and the effect of it, right?
Right.
So who wants to begin? Like what's like a case that you guys have where we applied, what we know about Lasley and the strengthening of an already existing regulation to really further our clients' interests?
I think your case is closer to Lasley and adjudicated, so maybe we'll start with that, and then we can speculate maybe on mine.
Yeah.
That's out on appeal.
Sure. So
also like riffing like that makes it seem like there's no script. Right? So like when I throw that out, right?
Yeah.
And then you say, oh, like let's start with, just a little
behind the scenes
sidebar. But yeah, go ahead, Tomer.
Yeah. So I mean, we got a file. We got a file where the claimant received a surgery for the knee, so a SLU site, back in January of 2023. The claimant then produced total medical and then some varying TPs or some partial disability medicals, but nonetheless continue to have their own medicals throughout the life of the claim since January 2023. The claimant then subsequently got another arthroscopy for his knee in January of 2024, then placing him again on the total train, we'll call it.
Total train. That's
that's
kind of cool.
Just came to me. I don't know.
Yeah. I want to derail that guy.
Wow, that's good. All right, let's keep it up. But yeah, so the fear was, because we got a SLU site and we got the NIAD issue, that we have all these payments, all these TT periods. The claimant's been voluntarily getting paid at total throughout this whole time. So the fear was that we're going to be entering that protracted healing period, the PHP period, for this file. So when we got the file, there was a hearing that was going to come up. So I remember filing Lasley versus Wegmans with the board prior to the hearing.
Oh, copy of the case to the board.
Yeah.
Okay.
Definitely. Just in case, OC, opposing counsel, or the law judge is unaware of what's going on, just to try and leverage that in a communication.
Okay.
So I put that in there, obviously knowing 310C exists too, but with this new case, wanted to see how I can leverage a favorable settlement or settlement of the issue for a degree at least. Since we already paid him voluntarily, it's not like we're going to get the money back or anything like that. But my fear was we're going to be in PHP territory as is, and the claimant just had a new surgery. So who knows how much further we're going to have to go with it. We didn't have our own medicals. There was no contradicting IME in there. So I remember getting on the phone, speaking with opposing counsel on it, and said, hey, this is either going to pan out where we can agree to certain awards at the rates that I'm going to choose. At that point, given that we've already paid him out, it made no sense. It made no difference, really, if it was 50, 60, 70, 90%.
Right.
Because all we wanted to avoid is the total finding. So I remember getting on the phone with opposing counsel then, and actually had to tell her, everyone was saying, like, everyone seems to be aware of Lasley versus Wegmans. I won't name drop, but this attorney was not. So I gave her that. I gave her the case law, told her to review it before, and she did. And ultimately, we came to an agreement before the hearing took place, and avoided 16 weeks of total, which saved our client PHP. I mean, we would have definitely been in PHP by the time permanency would roll around. We would have definitely paid an extra on top of the schedule.
Right. So even 16 weeks, that's for most body parts, that it's either half or more than half of the normal healing period already.
Mm-hmm.
So
Yeah.
almost using it outside of litigation. That's actually
Mm-hmm.
more interesting than what happened at, like, in the Lasley case, where you had to expend all this litigation effort
Right.
to get the result that you want. And I think it's okay to have that risk aversion feeling from our client's perspective, right? Like, when you go into litigation, right? We just talked about, like, oh, aren't we litigators here? Like, you could win or lose, right? And there's that risk that we can offset by still using our litigation leverage to get to an agreement where everybody can kind of feel resolved or have the case be resolved. Because from that perspective, Tomer, right, the claimant's attorney does not want to do depositions for periods of awards that have already been paid.
Right.
Right?
Exactly.
I don't know any single judge, and rightly so, I don't know any single judge that would want to litigate, hear and read deposition transcripts for periods of awards that have already been paid, right? It'd be different if we didn't pay those awards. And then from our client's perspective, anytime I see voluntary payments being made, I actually think of, like, a Good Samaritan, that you don't have to pay these, right? You don't have to pay the awards after the 30-day payer compliance period, right? And when we voluntarily issue benefits, we get punished for that, right?
Yeah.
So I think of this like this Good Samaritan. It's like, oh, I'm going to help this person that I don't need to help. And then, okay, well, the person died and you contributed to it. So now you're partially
screwed.
responsible for trying to help when you didn't. It's like, it's a crazy, crazy situation. That's a really interesting way to apply it. And then the case kind of moves forward and we can spend our time elsewhere.
Certainly cost effective too, because, who knows how many steps you would have had to do across months of providers and whatnot.
Not that it matters who the judge is. I do know this judge fairly well. That was before, and have made the argument for Lasley. He seems to misapply it consistently, but there is a time consideration too, because let's be real. If he's going to deny my argument for Lasley, we're going to have to appeal it, and we're going to have to come back and be at square one and do the whole thing over awards, like you said,
right,
which have already been paid.
Right.
So for me, the thinking was, there's no real, there's much more benefit, I think, to negotiating and avoiding the PHP off the bat, as opposed to litigating the issue and having it roll out as far as client costs with appeals, with deposition scheduling, drafting briefs, the whole thing. So, for this specific file, it made sense to have that conversation with opposing counsel.
Yeah, I think that in your case, there are very, very little reasons to litigate that.
Right.
Right. And then you're factoring cost, you're factoring chance of success, and then your claim history. So there may be times, right, where you will need to use Lasley in litigation because there's no resolution potential or an actual resolution is not beneficial to the employer. But in that specific situation, right, if we're retained and the implementation of total disability or the total train, right, and we're now calling it, has already left the tracks, it's already left the station.
Nice.
Right? Yeah. we have to kind of slow it down, right? If we're not going to ultimately derail it, we have to do something. You're loving it, just continuing the analogy. I mean,
that's good. It is good though.
Right? Yeah.
Yeah.
I think you're also enjoying that you came up with it. Right?
There's some of that, I guess. Yeah.
Yeah. But, in the situation where you have to use it in litigation, sometimes those costs are necessary for the overall bargain, right? Like, I don't think that Wegmans or its carrier would probably say to itself, you know what, we should litigate this rate here. Like, those rates were already paid. Mm-hmm. They probably now need this case to not do the depositions, but to negotiate a partial rate if they haven't done so already, or if they haven't litigated that on the administrative side. But that's a very good point. Did you have something, Brian? I think I might have cut you off, but if you didn't, we can go to your case.
No, I'll start with mine.
Yeah, so you have a case that's like in litigation, right?
It's on appeal now.
Okay, all right.
Not adjudicated yet, and it's a different situation than Lasley. It's actually a contested claim. We were in litigation regarding the compensability and mainly causal relationship. There are a couple issues, prior injuries, accident video that really showed non-injury, but I'm not going to bog us down in all those details. Essentially, in this case, we got an IME that conceded causal relationship, but there was issues with the claimant's medical records regardless. And it was our position that it's the claimant's burden of proof. We're going to push and depose the doctor anyway. We're not just going to accept the case and, inherit any liability. So we go to the hearing and I say, hey, judge, we want to cross-examine the doctor on causal relationship, the treating doctor. Law just says, I see there's an IME in the file conceding, basically puts a rubber stamp on the compensability, says, establish right knee.
We've seen that so many times before.
Yeah. Like, treatment authorized, NFA, have a good day. So I go back to the client. I'm like, this is ridiculous. So we filed an appeal citing Lasley, basically saying under the law, they must grant us the opportunity to cross-examine the doctor. We also had a few, facts that made litigation warranted. And also, ultimately, it is the claimant's burden of proof. In this instance, it seemed the law judge almost took the IME and relied on that for his decision, as opposed to the evidence proffered by the claimant, which is not really how it works either. So,
or how it should work at least. Like sometimes it is how it works.
Yeah,
like for how they adjudicate cases.
Mm-hmm.
But yeah, I guess applying it now to a different issue,
right,
is very interesting.
Yeah.
Because sometimes if you think about the fact that this regulation is already codified, it should already be applied just by citing it. You don't even have to cite it. You could say, I'm requesting to cross, right? Like those are the magic words. You could put it in a pleading, in RFA 2. And the case has to be, or the issue has to be held in abeyance pending development of the record. If you're bringing up Lasley to a judge and you know that the facts are, let's just say they know what the facts are, it's not as easy to make that hop from PHP, total disability, degree of disability, permanency, all that stuff, to now using it to defend compensability of the claim, right? It's not as easy for a practitioner to just make that hop. So now you have a very interesting application where we're not using it to, litigate what's been litigated in Lasley. We're using it to litigate causal relationship or compensability as a whole.
Yeah, the facts may not be analogous. You think of like law school legal brief,
right?
Compare and contrast the facts, but really it could be applied in any issue involving medical evidence that the claimant's relying upon.
Right.
We have the right to cross-examine their doctor if they're relying on that medical evidence, whether it's for degree of disability, causal relationship,
Treatment.
some other factor. It can't be, hey, your IME concedes, or you don't have, or maybe we got precluded. We still have the opportunity to cross their doctor, and make a case for our client, in situations where there's facts, where there's things to attack and whatnot. Obviously, we're not going to do frivolous litigation, but in my case, the judge made it seem like litigation was frivolous solely because the IME conceded, which is not really appropriate, I think, under these circumstances.
Yeah. It's interesting because we've discussed it, but what Lasley really stands for is this mandatory adjournment to allow for development through cross-examination of a doctor, right? That's really all it is. We're applying it to different fact patterns, and now we're trying to see Brian, expand on what's been done.
Mm-hmm.
And that's why it's really interesting to see how far we can take it and what other issues we could touch on. But if we look at Lasley, which again is not all that special because all it does is put into effect what already is. It's going to be something that I'd like to see how it pans out with this issue, with other issues that we address in workers' compensation. It should be something that is straightforward. And it just rarely ever is that way, I guess. But
yeah, I think that if it was straightforward, we wouldn't need to cite cases, right? Like
Good point.
The idea of saying I just need to cross-examine this doctor because I don't believe that this person 10 months post-surgery is totally disabled. I don't believe it, right? I don't need cross-examination, Judge, if you also believe that, right? So I'm almost using a common sense argument. It's like, because some judges don't want to go to trial ever, and so they'll try to convince you of reasons why you shouldn't go to trial. And we can still use that. We can say, like, Judge, I'm happy not to take a deposition of a treating doctor who will concede to sedentary work 10 months post-surgery. But the claimant wants awards at total, right? So we don't have to go through this whole charade where we take this testimony and the doctor's going to say, yeah, he could do a light duty job.
Yeah.
Right?
Sometimes it's like pointed at us because we're seeking a reduction.
Right.
But it's like they're here insisting on total, and we're like 13 months post-surgery.
Right, I know.
Like,
why they're never looked at as the reason that litigation is necessary.
It's like we're asking for it, but it's kind of because of the claimant why this is necessary, Judge,
I know. And I'm getting maybe a little bit off topic here, but I've had summations where I've said, Judge, I know that you've had to read 8 deposition transcripts in this case, but let me remind Your Honor that if those doctors put 75% on their reports like they testified to on the deps, we wouldn't need to be here.
Yeah,
right?
it is funny on degree of disability. We are going off topic, but on degree of disability, you can ask like 2 questions on the deposition cross to and they concede to 75% immediately.
End it. Yeah.
And then you're done. And it's like, okay.
Yeah.
But you're right. I think to kind of bring us back to the center here, right? You have this situation that, we spoke about Lasley in the context of bringing to light like what should be happening already, right? And to your point, Brian, in your case, it really like sets me off almost because let's just imagine that Lasley and 300.10c doesn't exist, right? This happens a lot in workers' compensation where our clients, in good faith get an IME, but the IME, and I'm using air quotes here because we don't have video, concedes causal relationship. That only means, if anything, that the defense of medical causal relationship is no longer viable. It doesn't do anything to sections 18, 28, right? Like all those other things that we raise because they're applicable. It doesn't do anything for coverage. It doesn't do anything for employer-employee relationship. All of those defenses, it doesn't do anything for intoxication, right? So to just establish the claim because an IME conceded is such an old practice that has still like not been shaken. And now Lasley is needed to like, suppress that, like just get rid of that. That's not a thing anymore.
Yeah, because
it never should have been.
Because I think judges and claimants counsel alike are frustrated. You know, they think they're going to that pre-hearing conference. Oh, IME conceded. We don't need to do claimant's testimony.
Right, yeah.
We don't need to do all this. They're just going to accept it.
Yeah.
And then you walk in and you go, hey, well, I want to cross-examine the doctor. And in this case, the judge said, like, just denied the opportunity outright.
Yeah, and, you know, even beyond that, because we see IMEs sometimes concede causal relationship, but their basis and rationale isn't there.
Or it's rooted on like the facts as they were resuscitated by the claimant,
Right.
which might not be accurate.
Right. If the claimant says, oh, no, yeah, I fell off a ladder, but he didn't.
Right.
Right.
So it warrants further investigation, even on the causal relationship aspect. If an IME concedes, you know, there's still things that we do. And I think we always do in our files, even when we get a bad IME like that, you know, we ask for development regardless. On that specific issue. I mean, I crossed a doctor today, asking, you know, did you form your opinion based off of the subjective history as told to you by the claimant? Yes. I mean, it's something that we should always be doing regardless of concession, no concession. Just because there's always a hole. There's always a hole in one of these doctors.
Yeah, they're not perfect just like us. Right. And I think that for the most part, they're used to taking claimants out of work when the claimants are already out of work, or if the claimant wants to be out of work.
Yeah, wants.
Yeah,
strong.
It's not a situation of like because you know you'll see, and our clients know this very well, when there is work status like current work status, like I'm employed, all of a sudden the disability percentage goes down, right?
Yep.
When it should be based on the physical exam and the limitations that the person actually has. So if you're a construction worker and you go to desk work, right, sometimes that changes the disability opinion, but that shouldn't really. It should be based on what this person can actually do.
Yeah. I mean, it's not to throw IME doctors under the bus either here that concede, or, you know, to say we shouldn't be getting IMEs or things like that. Because if you think about it from the doctor's perspective, the claimant goes in there, they report they fell, they report their knee hurt. He evaluates the knee. There's some restrictions. Is he supposed to say that there wasn't an injury to the knee?
Right.
You know?
That makes him less credible.
Yeah. It would be worse, right?
Right.
So, but there's always other facts, and maybe facts that the IME doctor didn't get or whatever. And the record needs to be developed further past just 2 medical reports often. And Lasley allows us to do that in a, I guess, venue that for a long time, it was very simple if the IME just conceded to just establish the case and move on. So,
yeah. I think, Tomer, you were mentioning that, right? That it's not so much that we shouldn't get IMEs because Lasley has elevated 300.10c, right? So what could you maybe elaborate on that a little further?
Yeah. So, you know, with Lasley and 310c, we should be getting cross automatically, but we still benefit from being able to rely on an IME's opinion. You know, for instance, if we were talking about degree of disability, we still can, you know, leverage that 50% or whatever the TP finding is that the IME has when we go forward and litigate the issue. We're not going in as blind almost if we go in without the IME. So Lasley does secure, I mean, hopefully it secures, whether it's applied by judges correctly or not, but it should secure development of the issue. But having an opinion to support our position makes our position stronger. So, you know, just because we got Lasley, just because we have 310C, I don't want it to suggest that we don't get IMEs, you know, moving forward or anything like that. We still should be getting IMEs. Yeah, that's my opinion on it, at least.
It's almost as if the absence of the IME doesn't put you at the mercy of the claimant's doctor, right? Like you can still litigate what's in the file without an IME. Does an IME help? I would say most of the time it does, right? Most of the time, here's your conflicting medical. And I think judges really see that as like, okay, I have to go to trial here, right? That's the more normal course of action when they see two opposing experts. I could also say that, hey, like IMEs, they do hurt you sometimes, right? Whether it's a concession, in quotes, of causal relationship or need for treatment or disability percentage. In theory, if the claimant's going to be the historian providing the details of the accident to the IME, then in some cases, it actually might be beneficial to not get one. So you have all these range of scenarios where, we can recommend to a client, don't get one here.
Mm-hmm.
We can recommend to the client, get one here.
Mm-hmm.
And then we can just say, you know what? Doesn't matter.
Worst case scenario, we could still depose the doctor.
Right. Get one or not get one. What do you want to do?
Mm-hmm.
Right? Because either way, we're crossing the claimant's doctor.
Mm-hmm.
And so I love how it just really starts ballooning into situations where, the legal theory or the recommendations that we provide are both endless and not repetitive.
Right.
And, it can't be replaced, really, because that's really the element of having counsel on a file is that counsel has experience. You're talking about a judge, Tomer, that this judge probably is going to deny it, right?
Mm-hmm. Yeah.
Fine. You're talking about a case where you see it all the time. The IME concedes and judge rubber stamps it, right? Like, you're not going to use those words if you haven't felt that pounding of the rubber stamp on many occasions before. Like, oh man, I'm going to get hit with this. Or, oh, I bought the shoulder. The IME said it's related. And a lot of our analysis goes into what happened before that result, right? Because if you attack the source, you attack everything.
Yeah. Yeah. I mean, everything like you're putting together, it's everything is a case by case basis, right? Everything warrants the level of analysis that we should be giving, and that we do give to our files. Is whether we need an IME in this case or we don't, is something that's specific to each file. But whether we should get cross examination should be, across the board guaranteed.
Yeah, I guess to tack on it should be like considered when possible. You could think of even, we were talking a lot about IMEs, but there's plenty of times maybe we didn't have the time to get an IME, or maybe we filed an RFA to suspend based on stale medical evidence, and then like the day of the hearing, opposing counsel uploads their temporary total report.
Right.
Now we don't have conflicting medical evidence, but you could say, hey, judge, I want to cross-examine on temporary total the doctor on the topic of degree of disability.
It's a good point.
Because then we don't just show up for a hearing and do nothing because a new report's in there.
Right.
It gives you another, little quiver in your pouch or whatever, or however, whatever metaphor you want to use.
It works.
To get them off I should have done a train analogy. I blew it.
It's like
You guys know what I mean.
Yeah. I would also say too that, that like 25th hour submission of new medical, right? It defeats, an RFA2 on its face, right? And sometimes turning that, that dial around and against the other side, the opposition, you're saying like, judge, this was just filed today, right? If this was filed a week ago, 2 weeks ago, maybe it'd be a different story, but you have to apply Lasley in 300.10c because this was just filed today and the claimant's using this for X, Y, or Z, right? And I think that's the level of the application of this particular case. Like 310C is like the bedrock of cross-examination of an expert, right?
Mm-hmm.
It gets brought to life by a case that has a lot of publicity, at least in our little world, right? I'm sure that when my mom's listening to this, she's like, Lasley is no different from like Smith or something, right? But it does have a lot of publicity. And now our role is to say like, what else can I do with it, right?
Mm-hmm.
What else can I do? So we talked about how, it shouldn't dissuade a client from getting an IME, right? In certain cases. Any other takeaways you guys can think of that maybe someone can say like, oh, you know what? I just don't like Christian's voice. If I just fast forward all the way to the end, get the takeaways.
Yeah. So I think something that we just kind of touched on and that's been consistent throughout the conversation is that Lasley rejects the idea that we take things completely on their face. So if if we just get the temp total report in the day of the hearing, let's not take it on its face. Let's request cross. If we get the IME that concedes causal relationship, let's not just take it on its face. Let's request cross. And that's what I think Lasley helped solidify beyond 310C. So that's why we got to use it.
Yeah, it should be considered when medical records, either the claimant, even if our IME concedes something, it should be an option at least provided to the client to say, hey, we always have this option to attack their doctor. I think we have credibility issues that are X, Y, and Z. It's an option when the claimant's relying on medical. Maybe they're relying on our medical or, our concessions. If that's their whole argument, well, the IME conceded, well, that's not really good enough. It's their burden. We can attack their doctor. And if there's usually some credibility issue we can find.
Yeah.
Especially on the degree of disability aspect, there's always plenty to work with there. So I think it should be considered.
Yeah.
Often.
Almost as if, hey, I have this option to use cross-examination and it's going to, hold awards in abeyance, hold the issue in abeyance. But I think the biggest thing is, where are we going to be with this claim 6 months from now, a year from now, right?
Mm-hmm.
If you get a demand for $1 million, right, you're not settling that one, right? So the push to litigate this type of thing, it might be costly, but is it as costly as $1 million settlement? No, right? Then take it conversely, right? If you're getting a demand for $15,000 in a case that's worth $50,000, well, we're not using Lasley, right? We're just agreeing to a settlement. And so I think that, what you guys are saying and bringing all these factors into play is exactly how really any development in the law should be used, right? The board could come up with new medical treatment guidelines tomorrow, right? It's just not going to always be applied the same way. So I think that is a very, very nice way to end it. Last one for you guys. When our clients listen to this, we will be in the thick of mock trial prompt 2, right? So, we have our current leader here, Brian. How do we feel? Are you feeling confident? You think we're going to have another repeat award this month?
We'll see.
Well,
I'm going to try.
I'm very humble. Yes.
Got to stay humble.
Yeah.
I'll try to put on a show again. You got to have fun with it. That's all I'll say.
Just for everyone else that I guess doesn't get the opportunity to, not that this helped you, not that this really won it for you, but you did make references to DJ Khaled.
That's true, yeah.
At the mock trial prompt. I think that definitely got you a few laughs and sympathy points.
Yeah, I will say Brian's not on my team this month. I'm a mentor in our mock trial this year, but he's not on my team, but I have high hopes for him. I won't lie.
Yeah, that's true.
Well, I hope I could, exceed those expectations.
There you
guys
go.
Just set myself a high bar,
Yeah, being first after round one, it's not always the best thing, but
I'll take it.
better than being last,
It's a
right?
good place to be.
Yeah, that's true. All right, so for Tomer Lehr and Brian Mooney, my name is Christian Cisan, reminding you to defend from day one.